happens when two prominent, well known startups claim trademark rights to the same name. As a lawyer, legal dramas like this give me so much joy, and I'm like here for it all, simply because you get to see the ingenuity of law and lawyers come out to play. Today, we're diving deep into the trademark war going on between Paystack and Zap Africa over the name Zap, and who registered first, who didn't register first, and who has or who officially has rights to the name. Hi, I'm Norma Grace, a corporate and tech lawyer passionate about simplifying complex legal concepts for businesses building in Africa's digital space. And if you're a founder, this video matters to you because trademark mistakes can cost you millions or even your entire brand. But let's rewind a little bit and give a brief background of Paystack and Zap Africa. We'll start with Zap Africa because they are the quote unquote older company for the purposes of this video. Now, Zap Africa is a crypto exchange firm that facilitates the swapping of crypto to naira and other, crypto based transfers. But they've been in operation since 2022 essentially. Now, Paystack, almost every Nigerian knows who or what Paystack is. They are a B2B, that's business to business payment solution that basically facilitates payments. In March 2025, Paystack launched its very first consumer facing product, which they call Zap by Paystack. And almost immediately, users of Zap Africa notified Zap Africa on Twitter, now called X, that hey, are you guys affiliated with Paystack's Zap by Paystack product? What is going on? Zap Africa got onto the chat, noticed what happened, noticed the launch, heard news about it, and immediately tweeted there is only one Zap in Africa and Nigeria, signifying that they were ready to defend their rights to their brand name. And that is where this all began. But let's rewind, let's go back a bit and find out factually what are the legal conflicts in this, what are the dates? Because again, you have to understand that trademark in Nigeria uses a first to file system. So who filed a trademark for the name Zap first? What are the timelines to this? Zap Africa started operations in 2022. Now, in Nigeria, Nigeria uses the NICE system of trademark classification, and in that NICE system of trademark classification, there are 45 classes, and each class has a specific thing that it protects, be that services or be that a product. Right now, Zap Africa started operating in 2022, and in 2022, they did not apply for any trademark registrations. Their very first trademark registration was applied for in October 8th, 2023, and it was under Class 35. And Class 35 is about business and advertisements and all of that. Now, again, they applied for another trademark in Class 42 in June 25th. Either they applied for it or they were granted it. Either way, it was filed in June 25th, 2024. Now, the third, and this is now where it gets very dicey. The third class of trademark that they registered in was class 36, which covers financial services, insurance, and all of that. Class 36. And they filed slash received their trademark license in March 27th, 2025. Now, the dates are very important, so please pay close attention to it. Now let's move over to Zap by Paystack. When did they file? When did they start operations and when did they file? Zap by Paystack officially launched to the general public in March 24th, 2025. Now, before that, according to Paystack, they had been operating in quote building on a low-key basis a year before that. And Paystack, being the prominent and well-known company that they are, they had taken some steps to protect their brand name and reputation. Now let's go over the dates again. Zap by Paystack applied for trademark protection of the term Zap by Paystack in class 9, class 35, class 36, and class 30, no, and class 42. So class 9, class 35, class 36, and class 42. Zap by Paystack applied for trademark registration in these four classes in December 2023. They did theirs at once. Zap Africa did theirs in stages. Now, Zap by Paystack came onto the Play Store in November 2024. Zap Africa, on the other hand, came onto the Play Store on 19th December 2023. Now that you've seen the dates, you've seen the dates, you've seen the hierarchy, the timeline when everything happened. Both parties are still standing strong and on their legal claims to the word Zap. And while all of this was ongoing, another thing surfaced, and that was that Zap by Paystack did not receive the appropriate regulatory compliance requirements or approvals from the appropriate bodies, which is CBN. Now, Paystack is again, it's a prominent, well-known B2B financial service company in Nigeria. So they already have certain licenses that they use. Now, according to news reports and according to what I was able to find out, allegedly, Paystack says that they are standing on their existing licenses to operate. But when you ask CBN, who is the regulatory body for financial services in Nigeria, they said, nah, Paystack needs to get a fresh approval. If you are launching a new product, you need to get a fresh approval for that particular new product because former or previous licenses were given on the basis of former products that you have. So for every new product launch, you must receive a brand new approval. On the other hand, now, Paystacks or Zap by Paystack offers international money transfers. And if you're going to conduct international money transfers in Nigeria to another country, you need an international money transfer license or money transfer operators license, the IMTO license, from the destination country and the sending country, right? So the sending country is Nigeria, the destination country is the UK. That means Paystack needed the IMTO license from CBN and from the UK's Financial Conduct Authority, the FCA. They are the ones that manage the financial services in the UK. So they needed the double-sided license. And even though Stripe, who is the parent company of Paystack, has the license with the UK's FCA, Paystack themselves do not have the license and they need the license to be able to conduct IMTO or to be able to conduct international money transfers. So do you see how dicey this whole situation has gotten? There are so many legal considerations, there are so many legal questions that these two seemingly innocuous acts raise. The very first one is I realized, or at least I noticed, that a lot of people began to confuse corporate affairs commissions or the rights that CAC offers you to the rights that trademark registration offers you. They are two completely different things, please. CSC is for your company name, right? Is a name that tells you that you are officially a company. You are now a business entity, an artificial person given the rights to operate. Trademark, on the other hand, it is a unique brand identifier. It communicates to the general public that, hey, this is my unique brand. You can identify my brand by XYZ. Either a name, a slogan, a sound, a color, whatever it is. They are not the same thing. They are not the same bodies. They are not the same regulatory approvals and they are not the same legal rights. And in this specific case, we are talking about trademark rights, not corporate affairs commission. So again, they're not the same thing, different things. The second legal consideration is that Nigeria and most other countries really uses a first to file system for intellectual property. So whether that's trademark, copyright, whatever it is, they operate a first to file. So whoever filed first automatically has the rights to that name or trademark or copyright, whatever it is, to that intellectual property. Now, if you go over the timelines again, you'll find that Paystack registered at once or applied for registration at once. Zap Africa, on the other hand, did theirs in stages, staggered by years, really. They did the first one they did in 2023, the second one they did in 2024, and then the third one they did in 2025. And the first to file system matters a lot because whoever filed first automatically has the right to that name. The third legal consideration is in the classes, the trademark classes. As I mentioned earlier, Nigeria uses the NICE classification system of trademark, and in that NICE classification system, there are 45 classes divided into products and services. Now, if I have a name and I register it in class A or in class 1, for instance, and you have the same name and you register it in class 2, I cannot come after you for registering my name in class 2. Neither can you come after me for registering your name in class 2 or in class 1, rather, sorry. So, do you see? The classes are very, very important. That's why it seems dicey when you hear that Zap Africa registered in class 16, class 35, class 42, and class 36. And Zap by Paystack, on the other hand, registered in the exact same classes. Because even though Zap Africa is into crypto and Zap by Paystack is into international money transfers and facilitating speedy bank transfers, it is both of them are in the same financial industry. So do you see? And these classification systems don't necessarily make room for the niche aspects of certain industries. All financial services, all insurance services are locked into class 36. All legal services, for instance, are locked into its own specific class. Does that make sense? So your class registration is very, very important. Another legal consideration is in the name. What name did you register? Now, Zap Africa registered Zap, just Zap. Zap by Paystack, on the other hand, registered Zap by Paystack. Do you see how it can get confusing for users of the product to think one is affiliated with the other? So not only is your class or the choice of classes you register in important, the name you choose or the slogan or the device or whatever type of unique brand identifier you choose to register also matters. So that it doesn't get confused with another brand and then have your brand become diluted because it is now being mixed and messed up. Another legal consideration is the brand confusion and the brand dilution that comes with both prominent fintech companies using the name Zap. Paystacks might be Zap by Paystack, yes, but it's still the word Zap, and it is liable to be confused one with the other. Because I mean, imagine even during the launch of Zap by Paystack, users of Zap Africa thought that Zap Africa was in one way or the other affiliated with Zap by Paystack. So much so that they received so many notifications on X about it that they had to tweet about it. And Zap by Paystack hadn't that was the moment of their launch. So imagine if this is something that is been in operation for years. Imagine the kind of confusion between the two companies and their users. You see, who wins out at the end of the day? Who takes the market shares at the end of the day? Because people will forever think that one is the other or one is affiliated with the other. Another legal consideration, and this one might get, public opinion on this might differ, but do you think, or it might be possible, that there was an overlap from the regulatory body and neither Zap by Paystack nor Zap Africa is at fault because they did their due diligence and the actual fault might have been from the regulatory body? That's also a consideration because it's entirely possible that such mistakes might and can happen, especially because of the word Zap. Okay, so now the way that trademarks work or the way that trademark registrations work is that before you even apply to register your trademark, you have to run a search. Now, when you run a search on that trademark, every single company that is registered with that particular name you want to register, even minutely, is brought out or it comes out as a result of that search. Now, it is up to you to either decide whether or not you want to go ahead with that registration or whether or not you want to change the variation of your name. So this is why I said that there might have been a legal consideration is that there might have been an overlap because there is a company that has been registered with the name Zap, trademark rights to the name Zap since 2008, way before Zap Africa or Zap by Paystack ever came onto the scene. So it's entirely possible that this many companies, Zap by Paystack, Zap Africa, and this other one in 2008 that was registered with the name Zap, are registered with different variations, as we can see with Zap and Zap by Paystack. So it's very possible that there was an overlap by the regulatory body. It's entirely possible. Another legal consideration is, does Zap by Paystack offer Paystack sufficient protection for them to use the word Zap as a standalone? Paystack says yes. When they were asked, they said yes. But personally, I don't really think so. Because they registered Zap by Paystack. So they are entitled to use Zap by Paystack until the courts say otherwise. Or, but they didn't register Zap. So they technically do not have the right to use the word Zap as a standalone. That right remains with Zap Africa that registered Zap as a standalone. And this is especially because both Zap Africa and Zap by Paystack were registered or are registered under the same class 36, which caters to financial services. So when Paystack said yes, that they have sufficient coverage to use the word Zap as a standalone, even though they registered Zap by Paystack, I tend to disagree. The generic nature of the name Zap is also an issue because normally trademarks or intellectual properties as a whole are meant to be unique. They're meant to be new. They're meant to be out of the world. Like they're meant to be new and unique. And the word zap is just not new, unique, or it's a very generic term. So when you register the word zap for a different purpose than what it's been known for, example, you know how we have Apple for phones and then Apple the fruit. Yeah, it gives it protection only to a certain extent, especially because there have been prior registrations of the word zap even before Paystack and Zap Africa came to play. So the generic nature of the word, how strong is it to be covered by trademark as a generic word? Yes, it's being applied differently, or yes, it's being registered in different classes, but still. Another legal consideration is that both parties have sent cease and desist letters to themselves. Zap Africa sent to Zap by Paystack and vice versa. Now, how effective these cease and desist letters have been is still to be seen because, well, is it really still to be seen? I think it's doing what it's supposed to do because neither party has been very aggressive with advertising or marketing their products since. Now, whether that is as a result of the cease and desist letters they wrote to themselves or not, still to be seen, right? Another legal consideration that I find really interesting is the battle between market dominance and legal rights. Now, market dominance because Paystack is the more dominant company in the market. They are, they've been around for years. They were acquired by Stripe in 2020. Their names, their founders, all of, the entire Paystack community has been up and up since it came on. And then Zap by Africa is relatively new compared to Paystack and relatively small compared to the achievements or the fame that Paystack has. Now, does that market dominance give Paystack any kind of undue influence or undue advantage over Zap Africa? In the same way, Zap Africa has been in operation longer than Zap by Paystack has been in operation. And so, therefore, first in time, does that then give Zap Africa such rights? Especially because Zap Africa's trademark registration was staggered and it happened in stages and in different years. In all of this, it just brings to mind the importance of legal due diligence, both with the trademark names and with Paystack's alleged regulatory non-compliance with the lack of, CBN licenses and the FCA licenses. It just brings to mind how important that is for you as a founder to take that very very seriously. Because yes, they might have done their regulatory due diligence, but once they notice, if I was Paystack, once I noticed that there were a lot of companies that had that name, I would have either chosen another or done something else that would have made me stand out better. This isn't just a legal battle, that much is clear. This is a battle, or this is a dispute over brand ownership, over your reputation, over the legal territory that you command, over regulatory compliance and all that comes with it. And so, in my opinion, here's what I think will happen. One of these companies would have to rebrand because the names are too closely related, too confusing to be allowed to stand on their own or to be allowed to be used by these two individual companies in separate, the same industry, true, but different niches, which is financial industry, and then one does bank transfers and the other does crypto. So I think, in my opinion, again, it's my opinion, I might be wrong, but it's my opinion and I stand by it. But I think that Paystack might be the company to have to rebrand. They might be the company to have to rebrand for two reasons. For two reasons. The first reason is that because of their regulatory non-compliance with the licenses and the IMTO and all that with the CBN, they didn't have, or they didn't take their product to get pre-approval before launch, and they added on a service that they had no prior existing licenses for, which is the international money transfers, that they needed both the IMTO license from CBN and um the corresponding license from the UK's Financial Conduct Authority. That's reason number one. The second reason is because, simply because Zap Africa had been in operation before them, and that in a way, I think that Paystack can bear the financial cost of a rebrand. Also, because Zap by Paystack is a fairly new product. They just launched it. Yes, they've been on the Play Store for like a year now. Well, not a year per se, but they've been on the Play Store since like November, December 2024, and they officially launched in 2025. So they're kind of relatively new. So they can take it. The name or the product is not as impressed in the mind of people as Zap Africa's product already is. So they can bear the financial cost of doing that rebrand and the public perception of doing that rebrand. They can handle it, as opposed to asking Zap Africa, who has been in operation since 2022, is a much smaller company compared to Paystack, to do a complete 360. That's my opinion. Now, on the other hand, because Zap Africa is not out of the woods either, because why would you? I mean, it doesn't even make any sense to me why you would register your core service, because financial services, it is your core business function. Why would it be the last thing that you register as a trademark? It should have been the first, before advertising, before being in class 42 as a technological, and it should have been the very first thing because it is your core function. So why did you register it last? And I understand that the several reasons might have caused the staggered registration. I understand it is totally understandable, and I'm not faulting anyone for that. But there were wiser or better ways to have done that. But again, I listen and I don't judge. So yeah, that is my hot take. One company would have to rebrand, and Zap Africa would have to, in one way or the other, bear the consequences of why they registered their core service late, or later than they did the others. But as a founder, enough of my opinion. As a founder, what are the lessons that you can learn from this? How does this affect you? Because you might be listening and you're like, this doesn't affect me. But it does, because this case will, if it goes to court, which I think it might, it sets the precedence for how trademark ownership and intellectual property as a whole is handled in Nigeria and maybe in Africa, depending on how long and the issues that are raised from this. So, how does it affect you, and what should you learn from this as a founder or as a startup? The very first thing is, please, please, this should be obvious by now, but please register early. Please, let's not dilly dally. Register, register early, whether it's trademark, copyright, whatever, even if it's your business name, register it early and do your legal due diligence. Even if you have an existing license and you are launching a new product, go back to that regulatory body and present your new product to them, because it needs re-approval or pre-approval before you can launch it again. The second lesson that every founder should learn from this is brand perception and brand protection is key. Because If the users of Zap Africa had not alerted Zap Africa to this ongoing situation when they did, Zap Africa might not have known. And that speaks to the beauty or the strong connection that Zap Africa has built with their customers. And it's actually a plus to them for them to have had customers, clients, users reach out to them on Twitter. And according to them, there were many. The people that reached out to them were many, for them to have seen it, over 9,000, whatever. But anyways, the point is that it's a plus to them. So your brand perception, your customer and consumer relationship, and your brand protection is very, very important. Do not play around with it. Do not play around with it under any circumstance at all. The third and one of the most important is, please don't ignore legal concepts, structures, and things you need in place for your business. Don't ignore legal. Do not ignore it ever. It's one of the core structures of your business. It's like ignoring legal is almost as consequential as ignoring financing. They have the same pride of place in your business. So don't for any reason ignore legal, because I can understand you say, oh, I need the money to run, I need this to do that, I need to blah, 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 blah. But if you now get up to those stages that you want to get to, a tiny mistake like this can bring your entire brand down. And nobody wants to work for years only to be brought down by something small or seemingly small in quotes. So don't ever ignore legal. Lesson number 4 that every founder can learn from this is, always conduct manual and digital searches on any intellectual property database that you want to register in, whether that's copyright, trademark, patent, whatever. If you're about to register a name, even if it's in a CSC, even if it's in CSC or any other, regulatory body, authority, whatever, conduct both manual and digital search. But some MDAs are still working with papers, and basing your entire company on the fact that you searched online and you didn't see something and so therefore it doesn't exist is not very accurate of you to do. So I would strongly advise that you conduct both manual searches. Go to that office. If you don't have someone to, if you cannot go to the office, find you someone that will. Go to the specific regulatory body's office and find out for yourself if whatever it is you want to register has already been registered before, so that you don't enter issues like this, because you know they can be avoided. Lesson number 5, register your trademark, intellectual property, whatever. Register it in as many use classes as possible. Now, if you see or if you check, Zap by Paystack registered in class 16, I think, class 35, class 36, and class 42. They did it. Zap Africa, on the other hand, registered in class 35, 36, and 42 as well. So you see, they registered in as many use cases as they could. In your own case, find out what your business does and how many use cases it will be applied in, and register it in as many of those use cases as possible, starting from your core business, the most important, and then moving on to other ancillary things. So if your core business now is, again, financial services, start from financial services first. Then you move on to advertising in class 35, on to technology in class 42. Then you move on to other classes. So start from the core, your core function, start from that, register that first, then you move on to other ancillary classes. But please, by all means, register in as many use cases and use classes as possible. Lesson number 6, get all your approvals early. Get all of your approvals early. If possible, get them while you are building, before it reaches the public, before it's out for the public to use. Get them. Don't launch first and then you now start thinking, oh wait, I have to do XYZ from XYZ body. That's not a sign of a serious founder. Get your approvals early. If you are not sure, reach out to somebody. I am sure that if not you having a direct contact to a lawyer, somebody in your network has a direct contact to a lawyer. Reach out to them and ask them, this is the industry I work in. How or what are the regulatory approvals I need within my industry? And they would help you out. Lesson number 7, avoid using generic names for your trademark or any of your intellectual properties, really. By all means, avoid generic names. If at all, like if you've checked and you must use a generic name, then give it an entirely new meaning. Example, apple the fruit and apple the phone. They have nothing to do with the other. You see? That's why that's why it works. Because now Apple as an instance, Apple has been able to distinguish itself as a tech company that does XYZ while removing or taking nothing away from Apple the fruit. So if by all means you must use a generic word, make sure that you distinguish it from the origin meaning, so that you don't have this, oh, it's a generic name, and you don't have, issues like this, or having it be very easy for someone else to copy or to use the exact same name that you have. Lesson number 8 is that don't think that your market cap or your revenue or your brand perception or any of these accolades that you might have, don't think that they insulate you from being held accountable by the law. When the law wants to, it will hold you accountable. So don't be prideful, don't be arrogant. Always keep up with industry updates, especially as it affects your business, your startup, your product, whatever it is. Keep up with them. Make sure that you keep up with them and you train your employees to look out for them, so that you would, if you personally as the founder is unable to look out for those industry updates, you have one or two other people on your team able to do that. So those are the 8 lessons I think that every founder can take away from this debacle between Zap Paystack and Zap Africa and this trademark war that they have ongoing. By the way, this is an ongoing story that will continue developing as time goes on and as more evidence comes out and as more things happen between the two companies. But what do you really think? I want to know. Drop your comments, drop your thoughts in the comment section. Whether that's a business thought or a legal reasoning or even just a rational, logical opinion. Drop it in the comments. I really, really want to know. I really want to know. Because do you think Zap Africa should go ahead with the name? Or do you think they don't have a case at all? Or do you think Zap by Paystack has the better case? Whatever. Let me know in the comment section. Now, if you're a founder or you're a startup and you're building anything in the fintech, crypto, or even in the digital space as a whole, you need to subscribe to this channel, because in this channel, we do not just build products, we protect what we build. And that's it for today, guys. Bye.